Let me now say a few words about EU law. Here's a quotation. The main goal of the EU is the progressive integration of member states' economic and political systems and the establishment of a single market based on the free movement of goods, people, money and services. To this end, its member states cede part of their sovereignty under treaties which empower EU institutions to adopt laws. This statement takes us back to another long-running theme that we've looked at in different ways throughout this course of lectures. To be part of the EU is to surrender, if you like, that element of sovereignty which one cedes to the EU institutions themselves. Now, it follows that law is of incredible importance to the Union, not least the connection between legal values and ideas like democracy and the rule of law, but to the functioning and to the running of this single market, this supranational structure. In other words, EU law has to be the same throughout the Union. And a lot of the problems and the issues, the legal issues raised in this area, I think, take us to this fundamental issue. These are perhaps too difficult to deal with in this introductory course, so I just want to say some basic things about the structure of EU law, given our understanding of those objectives of the Union. So, EU law can be divided into two types: primary legislation, the treaties themselves, like the Treaty of Rome, and secondary legislation. Secondary legislation is defined by Article 249 of the Treaty of Rome. And here is Article 249 of the Treaty of Rome. Quote, "In order to carry out their tasks, and in accordance with the provisions of this treaty, the European Parliament, acting jointly with the Council and Commission, shall make regulations and issue directives, take decisions, make recommendations or deliver opinions. A regulation shall have general application. It shall be binding in its entirety and directly applicable in all member states. A directive shall be binding as to the result to be achieved upon each member state to which it is addressed, but shall leave to the national authorities the choice of form and methods. A decision shall be binding its entirety upon those to whom it is addressed. Recommendations and opinions shall have no binding force." Now, the early years of the Union, particularly in UK law, generated a great deal of case law over the precise meaning of this article. It was then called Article 189. The articles of the Treaty of Rome have been renumbered, so Article 249 now, Article 189 then. In crudest summary, regulations are binding on member states. They do not require member states to enact legislation. Provided that they are sufficiently clear and unambiguous, they give rise to rights which can be used in national courts. Directives require member states to give effect to their terms in domestic law. The Court, or the European Court of Justice, has approached directives in a particularly creative manner, as explained by the British Court in Van Dyne and the Home Office, reflecting on this feature of the European Court of Justice's activities. Quote, "Where the community authorities have, by directive, imposed on member states the obligation to pursue a particular course of conduct, the useful effect of such an act would be weakened if individuals were prevented from relying on it before their national courts, and if the latter were prevented from taking it into consideration as an element of community law. However, as stressed in Van Dyne, it is necessary to determine whether the, quote, general nature, general scheme and wording in the provision in question are capable of having direct effect. The directive would have to be unconditional and sufficiently precise in order to give rise to direct effect, in other words, to create rights which a citizen could use in court. Unlike regulations and directives, decisions, and obviously I'm just elaborating the terms of Article 249, Article 189 also, before it was renamed. Unlike regulations and directives, decisions are addressed to specific parties, a member state, company or individual. Decisions are EU laws relating to specific cases. They emanate from the Council, or the Council acting in partnership with the European Parliament or the Commission. They create binding obligations and can be used to prohibit, enable or to confer rights. So the technical nature of these different forms of secondary legislation aside, we're considering the fundamental structure which allows EU law to be applied in the same way in the different legal systems of the member states that compose the Union.